Hi everyone, I'm attorney Poonam Minhas, and I practice U.S. immigration law all over the United States. Today's topic is going to be about a recent successful N-400 case. But before I jump into the topic, make sure to hit that subscribe button and hit the bell icon to stay updated on anything I post on U.S. immigration law. Like my videos, share them with your friends and family because you never know who this might help. But if this is not your first time here, welcome back. Let's cover this topic. I was approached about a certain situation revolving around an N-400 application that was filed pro se. Again, pro se means that the applicant decided to file the application by themselves without the help of an attorney. So the application for the N-400 was filed, and the client had told me that he had a very difficult interview. And after the interview, he received a request for evidence. And when he received the request for evidence, he did respond to everything timely. But what ended up happening was he started panicking because he got something called a notice of intent to deny. And in the immigration world, we like to call it NOID. So when the client received that notice, he panicked. He thought, oh my God, my N-400 application was denied. Oh my God, now I need to do an N-336. So when this call came to me initially, I was looking for an actual N-400 denial when I was going through the documentation that was presented to me prior to setting up our detailed consultation. So I'm looking through everything and I'm like, where's the N-400 denial? But then I came across the notice of intent to deny, and then I saw the date on there and I was like, oh, this is fairly recent. Okay, hold on. Let's pause. Let's set up this consultation and discuss this further. So I had told the person, the applicant who sent me the documentations, I'm like, hey, wait a second. You didn't get denied your N-400. In fact, you received a notice of intent to deny, which means that now they want to make a decision, but USCIS needs more evidence from you to decide whether they should deny your application or whether they should approve it. So while the prospective client was panicking, and when I finally explained the situation to him, I explained it in a way like, hey, you know what? I understand and I can sympathize that you had a very rough interview and you've already presented whatever you had during the initial phase of receiving the request for evidence, aka the RFE. But now this is a good opportunity for you to get a second bite of the apple. So you're given a second chance by this USCIS officer to plead your case further in order for them to make a decision on your current application. So to me, it was a great thing. And, one of the things I did like about the situation was as soon as the NOID was issued, he decided to contact me, share his documents, and really get to the bottom of it to see what the issue was. So now I'm going to cover a little bit about what the issue with the N-400 itself was about. So a lot of times, even when I get initial phone calls or emails about, I was physically present in the United States, and it's based on the requirement, like you need to, if you're applying for citizenship and you're under the 5-year rule or the 3-year rule, depending on what rule you qualify under, there's a certain amount of days you need to show immigration, like, oh, I've been in the US. But that's called like the physical presence part. But there's also another prong that is usually determined by USCIS interchangeably, but you also need to meet this requirement separately. So a lot of times applicants get confused and they're like, oh, physical presence, I met it. What are they talking about? They're totally wrong about this. But there's also another prong, and that prong is continuous residence. So when does that get triggered? That usually gets triggered when you decided to take a trip abroad and you're outside for more than 180 days or less, and less than a year or so. And it also gets triggered if you've been outside of the United States while as a green card holder for over a year. So there are certain requirements that are met for the purposes of the citizenship application. So in this scenario, it wasn't a physical presence issue, it was actually a continuous residence issue. And the allegations were about, hey, you know what? You abandoned your residency. Like, you don't have strong ties to the United States. You're not able to prove that. And I think another thing that really made the situation a lot more harder and it caused more panic was the language where it said, well, what are your extenuating circumstances, right? And if you have extenuating circumstances, fine, can you prove that to me? Otherwise, it's going to go against your good moral character. And I know instantly when people see things like that on their NOID, RFE, or denial, they panic and they put their hands up. But I'm a good person. You know, how can you say that it's going to go against my good moral character? I am a person of good morals. Yes, of course. But it's just something that USCIS looks for in order to determine whether this person qualifies for U.S. citizenship and if they're worthy of becoming a U.S. citizen. So there was a lot of stuff in there where it did cause panic. It did cause, a big question mark, but I gave everything I needed. So anyway, fast forward, we strategized. I heard the whole situation. I inquired to find out what happened at the interview. I understand it was very, very difficult for this person, but we developed a case where we submitted a very strong NOID response, and we submitted a lot of supporting evidence. Believe it or not, the client thought, this is all I have. But believe it or not, when we really thought outside of the box, there was a lot more evidence he was able to gather and present it to immigration, where we submitted the case a week before it was due. And believe it or not, the day the actual NOID response was due, that was the day where we both woke up to, hey, you've been scheduled for an oath ceremony. So what does that mean? The N-400 application was approved. So I do have a message to all of you out there. If you are in the process of filing for citizenship, or you're in the middle of dealing with the RFE or a NOID, or my client has said, hey, don't lose hope, because I could feel that he was also at the verge of being in that situation where he almost lost hope. But we presented such a strong case that USCIS had no choice but to approve it. And, we were ready just in case if it turned out to be a negative response or outcome, because ultimately the decision is in the USCIS officer's hands. It's discretionary, and it's depending on what type of evidence is presented, and if there's additional questions, or, maybe it's not up to their mark of, okay, you know what, this is approvable or not. If it's not, then we were also prepared as a backup that this is a case that should have definitely been appealed, because there was so much strong evidence to show that it should be leaning in the favor of an approval. Sometimes when you work with a client how much this is going to lean towards an approval or not. So I just wanted to share that with you today. I think it was a wonderful case that I recently worked on, and to get an approval within 4 days of filing a response, that's like incredible. Client is happy, I'm happy, their whole family is happy. It's just a great feeling. So I wanted to share that with you, because I know a lot of people have also commented under my previous N336 videos saying, keep us updated. Let us know about more N336 successes. But I wanted to share this one specifically. This one didn't even go to a point where we needed to do an N336. So if you're in a situation where you feel like, okay, now I need an attorney to step in and really help me because I have no idea what's going on, and to just clear the confusion, get on the phone, contact us, let us know if you want to schedule a consultation. Remember, initial consultations with my firm are free. 10 minutes, general in nature, just to talk about your case. And if it now leads into something where more details are required, where we have to review the notice, maybe that's a step you need to take to see what your, outcome, actually what type of relief you can probably qualify for. So every case is different. I know another thing I want to mention is like when people come to me, they're like, oh, but my case is similar to so-and-so, and my case is similar to this person or that friend. At the end of the day, that's not true. Because even in this same case with the client, he had told me, oh, my case is very similar to my father and my brother. I actually also reviewed the documentation for his family members, and I told him why their cases were different from him. And he realized, okay, you know what? I have to accept the fact that my case is unique. It is different from, my family members. And it was just part of the process. Sometimes you really have to hear it in a way. I know it's difficult to hear the truth, but the truth is what sets you free. So, I hope today's video was helpful. Again, if you have not subscribed, this is your chance to do it. Hit that subscribe button. To stay updated, you have to hit that bell icon. And I will continue to share any information I learn about immigration law, any successful cases, if I can share certain nuances of what those cases entailed. I hope it helps you. And remember, these videos are all for informational purposes only. None of them should be considered legal advice. To really understand your case, you should consult with an experienced immigration attorney, sit down with them, go over everything in your case before filing if you really are stuck and you're unsure whether you should file a case or not. So thank you again for watching, and I'll be back soon.